Okay. All right, we're recording. So let me go ahead and, let's kind of take it back, John. I just called John J. Singleton, the great, who's been helping people across the country with the legal issues we're all facing as a result of the coronavirus global pandemic, scamdemic hoax. And at thebigvirushoax.com, I just received an email from a fellow who says, "Hi, fellow Florida patriot here. I live in Palm Beach County. Will be filing an OSHA complaint against my employer. Do you have any recommendations for constitutional attorneys in the South Florida area?" So I gave John Jay a call just to, see if I could reach him. Unfortunately, I did, because he's busy, busy, busy. I'm glad he was able to answer the phone for me this morning. And go ahead, John. Let's repeat, because we got talking again. John and I were talking, and we're like, man, we got to record our phone conversation.
Yeah,
So
it's a good
John,
idea, Mike. I should do that more often. Yeah.
yeah,
Uh,
definitely do it,
so,
John.
yeah, my response was that you're wasting time with OSHA because you get into the quagmire of having to prove the efficacy of health measures, and that's not even relevant. The relevancy is whether or not the employer has the authority to impose a medical intervention on its employees. And so the way I found is the best way to state a cause of action is for violations of the Americans with Disabilities Act, and specifically with an employer, it would be Title One. Title One is, you can search it up on the internet, Title One of the Americans with Disabilities Act. It's codified in Title 29 of the CFR, Part 1630. You just should read that, and you'll see the companion parts are parts 2 and 3. Two has to do with government agencies like cops, courts, things of that nature, and then public buildings. Title 3 has to do with retailers. Okay, so Title One, ADA, I believe, is way better than OSHA. You're not going to find an attorney. There's no such thing as a constitutional attorney, okay? But you're not going to find an attorney who's going to help you. And even if one wants to do it and has good intentions, lots of times what I'm finding is they're just going to sabotage the case and they're going to do it deliberately. Or if they just really want to help you, they actually can't help you because there's a competing interest with the bar membership and the courts and the commercial incentive for what's going on with this fake pandemic. You're just not going to get the help from an attorney. The best bet would be if you can use an attorney, if he'll shut up, stay in the corner and do your research for you. And then you tell him what to do and then you write everything and express the case. So Title One, ADA, you send a complaint to the Department of Justice. Now, you also send a complaint, and I have a letter here I can share with you, Mike. You can pass it around. There's the purpose of this letter is to launch a mediation conference. You don't have to do this first. You can just flat out sue them because there's no notice requirements and there's no immunity. So you could sue anybody right away. But just the same, I would recommend do a complaint to the DOJ, your state attorney general's office, and the employer, and copy the Key Bridge Foundation. And that is the outsourced agency for the Department of Justice, and I'll give you the letter so you guys have all that stuff on the addresses and everything. But the point is, you're going to ask for help from the Key Bridge Foundation to get a mediation conference going. And then that brings everybody to the table. And I'm going to tell you what the issues are. If your employer is treating you or acting as if you are, or you have a contagious disease, then you're considered or regarded as having a disability. Therefore, you're protected under the ADA. It doesn't mean you have a disability. It just means that that is your legal protection. So you have to act as though you are. Okay, so then you say, okay, fine. If you want me to accept what's known as a mitigation measure, like wearing a mask or staying 6 feet apart or taking a vaccine or whatever, giving up my temperature, okay, which is a medical examination, this is a mitigation measure. And under the Americans with Disabilities Act, no one is required to accept a mitigation measure. You can reject it. And you can propose your own, which is leave me alone. I don't need to do any of this stuff. Okay. What you'll do by this is when you do the ADA case and you get past this issue of, okay, you're regarding me as having a disability, and there's a way you have to express the disability so that it shows that it's actual. Like, for example, anybody who wears something over his face all day probably is unable to breathe very well. So that's a disability, okay? If your head is held underwater, you have a disability in that you can't breathe water because you're not a fish, okay? So we can express a disability. Now, some of us really have something that's documented. That's fine. We can use that too. But what's going to happen is you're going to box the employer into this one pigeonholed situation where he's going to have to prove that you're a direct threat,
Right.
and there's scientific standards. We don't say someone's a direct threat just because Anthony Fauci said that on CNN. No, each person has to have an individual assessment under the Americans with Disabilities Act. This is required. It's by a scientific standard with modern medical standards, okay? That individual assessment, of course, can only be conducted with informed consent. You have to agree to it. There has to be cause for it. So
Right.
that's what you want to do, is get him into that situation where the employer finally realizes that he's not going to be able to establish that you're a direct threat. We're not even talking about if there's a contagious disease floating around yet. We're still at stage 0, which is you can never prove that you have the right in the first place. And all this stuff comes from the informed consent rule. It applies everywhere in the world, thanks to World War II. I think that's one of the good things we got out of it, was that people have the right to informed consent regarding the health of their well-being.
Right.
So, yeah,
So yeah, as you know, John, I'm was doing my best with a million things going through my head, man, to let you say, because I want you to get everything off your mind for the benefit of people watching this video. Um, right now, obviously, you're dealing with a lot. You're dealing with Title I, Title II, Title III. You're
hmm
dealing with a lot of different cases. Employee
right.
cases,
hmm
as well as people. The big one that I'm always addressing. If I'm not sure how many,
Retailer.
because I forward you our emails, and I know you're
Yep.
busy. So you know that if you've seen any of my emails, the big thing that I'm harping on is Title III. That
Yep.
places of public accommodation, right? 42 USC non-discrimination mandate. I
Yep.
have access to all the same services, facilities, right? I've
Right.
harped on that a lot. And, one of the big things I always say about that is, yes, you can't deny me access. You can't violate my rights without due process, like you're referring to. It has to be
hmm
court ordered, evaluated. You
Right.
can't just, you can't take somebody's rights away from them without due process. And by law, I have the right, you have the right, we all have the right to enjoy the exact same access to and
hmm
benefits and privileges and accommodations and services in any place of public accommodation. I mean, that is so obvious. And as you know, on the bigvirushoax.com, on our face mask dangers and law page, I've put several videos of me just discussing that, from a common sense perspective, and I've sent it out to every sheriff in the
Yep.
state of Florida numerous times, to the governor, to the mayor in Miami-Dade County, the police director, to some other government
hmm
officials. What's the name of, again? Anthony Sabatini. Have you worked with
Yeah.
him at all?
I offered to work with him, but he doesn't need my help. But I just wanted to work with
Right,
him. He was helping a gym owner. I was in another state, and he's also a senator, I believe.
right.
Uh, no, it
Do
wasn't.
you
It would
know?
it
Do
would
you
be in
know?
Florida. It would be in Florida. Yeah.
Right, he's
So
in Florida, and I haven't had the opportunity to speak with him yet. He's busy like you.
yeah.
He's
Right.
constantly dealing with things. Do you have any? Have you heard of any of his cases, success stories, or things that
I've
he's?
read I've read summaries of what he's doing, and I happen to agree with a lot of it. I think there are some attorneys that are doing the right thing and they're bringing the right issues up, because
Right,
what we have is it's an intangible property right issue. It's not really constitutional. It's an intangible property right. You can't take my intangible property right. You can't violate that right. I have a right to decide what I'm going to wear today, and I don't even have to tell you what it's going to be, right?
right,
The only response that a retailer would have, or an employer or somebody, is that they could overcome that right if you're a direct threat. And the way to frame that is under the Americans with Disabilities Act.
right,
And yeah, I mean, another phrase or word, way to describe it is due process.
right.
That
And
is due
like
process.
you're saying, and putting
Yeah.
emphasis on it, it says an actual direct threat,
There
right?
has to be a direct threat, right?
Right. It can't be an assumption, an
And
invisible enemy.
a direct threat is not because I say it's a direct threat. There actually has in fact to be a direct threat based on scientific standards, and not a spurious conclusion, something I just made up or heard on the news and then apply to everybody. Like for example, we would look at the Salem witch hunts as ludicrous, right? So you had all these guys create the image of what a witch is, and then they said she's one, she's one, she's one. So they
Right.
could remove prominent women from society. Well,
Right.
that's what they're doing now. They're just saying everybody's a threat. There he is right there. And no, it
Right.
doesn't work that way. We
Right.
live in a civil society. So which way do you want it? Do we get to work things out with words, or can we meet in the middle of the street and beat each other up until someone gets to walk away?
Right.
Because maybe that might be better. But for right now, we still have due process. We still have laws to follow. And if you guys are
Right.
talking about, your retailers and your employers, you're talking about you have a duty of care, which by the way, you don't. You don't have a duty of care when there's a pandemic. Okay, even if there was one, you don't. So if you're talking about let's follow the law and there's a law requiring mask wearing and all this, okay, well let's follow the law then. Let's read
Right.
it. The ADA. Prove it.
Exactly. ADA.
Burden of proof
So
is on you.
right. I was talking with Brian earlier today, and when he mentioned to me at first, the approach you're taking now, I was kind of beside myself. I was like, well, wait. I mean, because I'm thinking in terms of, again, the person's right going into a place of public accommodation. It's just a direct, you can't take my rights away from me, period, without due process. And here's what the law says, 42 USC, I have the same access, right?
Yeah.
But then it dawned on me, John, it was interesting. All of a sudden, I got a new wrinkle in my brain. I said, wow,
Mhm.
actually, the approach John is using, it made me think of the idea of, when did they ever have a law? I mean, my understanding is tuberculosis is contagious. When did they ever make a law that says if you have tuberculosis, you have to cover your face to go into a store?
Right. And that was recent. I mean, tuberculosis is still a problem.
Right.
Where's the emergency there?
Exactly. Where
Yeah,
where
that's
where
a good
has there ever
analogy.
been an emergency where they're thinking that they can force somebody to cover their vital airways, rebreathe their own carbon dioxide all day, and their mouth-filled bacterial waste in and out of their lungs all day long? You know,
Well, if you look at the whole scheme, they're using the people behind this are using the Department of Health to use the private businesses to enforce an illegal policy that makes it difficult for you and I to remedy. So now we have to use the courts. And how do we do it? Well, they took that away from us years ago because nobody goes to the courts unless they go to get an attorney, and they created a whole new language in the courts. So when you
right?
go there, that's why it sounds weird to say, I didn't even like thinking like this a couple of months ago. Gosh, I really don't want to make a complaint under the Americans with Disabilities Act because I didn't understand what it was being used for until I really studied it. And then it hit me. I was like,
Yeah.
okay, in order for us to take a complaint, a controversy into the court, you have to frame it in a way that the court has jurisdiction. And you can do it, you can ask the court for an injunctive relief. But if it's a hot issue like this where the court's involved with the fraud, it's hard to do that. But if I come in there with an ADA, and I'll give you an example of how this works. If I come there with an ADA issue, they can't, I mean, they can say it doesn't state a cause of action, but an ADA complaint has the best chance of stating a cause of action. And this is above and beyond claiming a religious exemption. And I want to comment on that because there is no exemption because there's no legal duty. And there's two aspects to the religion part of it. One is you have a religious conviction that maybe precludes you from participating in this, but the actual mitigation measures, such as mask wearing and social distancing and all those things, those are part of a demonic cult, a death cult. Just understand that a cult is a religious association. That is a so you can't be forced into a cult and you can't have your religious convictions violated. But just the same, it's hard to state a cause of action in court. Now there are some attorneys that do a really good job with this. If you want to go that route,
And I'm sorry, John, clarify for the viewers cause of action.
okay, that's a good point. I'm sorry. Okay, a cause of action means, let's say we have a contract that's in writing, and let's say you breach the contract, so I sue you for breach of contract, and I have to say certain things to the judge. So I say, we had a contract on this date, and then for consideration for the contract there was $10, and then he promised to do this, and I promised to do this, and then I say he didn't do it, and now he owes me X. And I asked the judge for a remedy. Now I missed one thing in that whole that I just listed, that list there. I didn't show the contract. So then you would come back and say, well, judge, yeah, sure, he's right. I mean, I do owe him and everything, but he didn't exhibit the contract that he said I violated. And so therefore you don't have the authority to hear the case because he didn't say it right. So that's called stating a cause of action. So if I made a mistake, then I would just go, oh, sorry, can I have a permission to amend the pleading? And I'll come back and I'll add that in there. And then we can maybe get on with the case. So when you sue them under OSHA, for example, I know they're easily going to win on a motion to dismiss, and they're going to say you didn't state a cause of action because probably you're going to have to argue OSHA um, standards. And if you go look at the OSHA manuals, they've perverted them. They just polluted all the manuals so that they took their longstanding OSHA's been around since 1970, so we're talking about 50 years. They took all their research that government we paid for, billions of dollars of medical research in OSHA to establish safety standards, and they took all these manuals and they on the internet they modified the PDF files and put red ink on the binder that says outdated or some version of that. So that way you couldn't even bring it into a court of law anymore because they're just going to say, well, look, OSHA itself says it's outdated when it's actually not outdated.
And this is something they recently did.
Yeah, they recently did this. So you're going down a path where you're just never going to get there. You're going to have to reinvent the wheel. I mean, sure, you
Right.
can get, there's a woman who is an OSHA expert. I think her name was Tammy or something. And you can get her deposition or take her deposition. But again, you're going to get, you're going to get bludgeoned. Okay. Trust
Right.
me. You come in
Because
there
the
with
bottom line is OSHA doesn't want to be in, OSHA got themselves in a pickle in a way. They
OSHA's
don't,
participating.
or they're
OSHA's
participating.
participating, absolutely. And if you go down that route, what's going to happen is even if you have $1 million behind you and you brought in a bunch of expert witnesses, what's going to happen is the other side is going to come in with their experts. It's going to be total BS, but they're experts, and it's going to cost you a $2.5 million, and you'll never win. You'll
Right.
you'll just hit this impasse.
Right.
But if you say, look, guys, I don't care if there's a pandemic or not. You don't have the right to force this on me unless you can prove I'm a direct threat to someone else. How do I frame that? ADA.
Exactly. Yeah. So the
That's way
direct
cheaper and
threat
more
comes
effective.
back not just to that, the direct threat then applies not just in terms of a person's access to a place of public accommodation, but it applies to a person working.
Yeah, your employer. Okay,
Right.
it applies that where you have access to the court or a public library or any
Right.
public facility, utility, public place, that's owned by the county.
Right. So in other
Uh,
words, the people that are concerned about being told in their place of public account and being told in their job, you have to cover your vital airways. They're essentially taking an approach. The approach you're recommending is one, and let's help define this, is ultimately saying in the big scheme of things, you have to prove that I'm a threat.
okay, let me frame it. Okay, so what you just said is you have to follow our mask wearing policies, right? So let me put this in
Yeah,
different
let's
words.
role play, and that'll make it real
Yeah.
clear for
Okay, but
everybody.
here's what's actually happening. I'm going to give you guys words to use. I want you to understand it this way because we see this on the surface. They're telling us we have to wear a mask. Here's what they're telling you. We think you have a disability because we think you have a contagious pathogen that you're going to infect everyone else, and that we think you're a direct threat to others. Therefore, we want you to accept and comply and submit to this mitigation measure. Here it is: wear a mask, etc. Your response is, okay, prove I'm a direct threat. That is what's going on here. And that is how you articulate the whole thing. If someone says you have to wear a mask, my response is, I don't want to accept that mitigation measure. Do you have another one? Or
Gotcha.
let me propose something else. How about if I don't do anything and you leave me alone?
So
Because I
what
have
you're
to go get my
saying,
groceries. Yeah.
so
Yeah.
elaborate on that. That's important then, because you're saying,
Mhm.
because you said there's a law on that, the mitigation. So
That's right.
clarify that.
In the Americans with Disabilities Act, there's a provision that says in there that when someone regards you as having a disability, which includes having a communicable disease, that is considered to be having a disability. That person or whoever can recommend a mitigating measure. For example, if you're blind, okay, we're going to do everything with audio. That's a mitigating measure, right? If you have a hard time walking, we're going to give you a walker. Maybe you need an oxygen tank, whatever. Okay, if you're deaf, etc. We have mitigating measures for these things. Well, one of the disabilities is having a contagious disease. And if they treat you as if you have a contagious disease and then they propose a mitigation measure, you actually have the right to say, I don't want that. And I still get the right to equal access
So
unless you can
can you,
prove
can
I'm a
you,
direct threat.
yeah, do you have that off the top of your head?
Yeah, I can cite it.
Yeah, can you
Okay.
cite that for me?
Okay. Let me give you, let's see. Okay. Title 29 of the Code of Federal Regulations, Section 1630. That's your Title 1 of the Americans with Disabilities Act. That is your section of regulations. The regulations give you all these definitions we're talking about. The statute is what Mike said, Title 42 USC 12101 or 121000. Okay? That's your statute. 42 USC 121,000. I'm sorry, 100. The regulation for, let's say, retailers, okay, Title 3 retailers would be Title 28 of the CFR, which is the Code of Federal Regulations. It's in Part 36. And I believe the section that talks about not being required to accept mitigation measures is going to be uh, Part 36.203 C1, if I remember correctly. But if you read it, it's a very quick read. You can spend a half hour on this and just get like 90% of it.
Right.
So yeah,
Well,
if you go to
I printed
yeah,
out Title III and read the entire thing.
there you go. Yeah. So Title III
And
is found
I've
in,
recommended to people, and they should. It's on our website. We have it at thebigvirushoax.com
yeah.
on the face mask dangers and law page, just to be sure. I'm going to be
And so let
actually
me summarize again the
civil rights and
language.
liberties.
Let me summarize the
Just so people
language.
know, they can print it out.
Yeah.
Um,
You can Google this. Go to ada.gov and you can search on keywords.
right.
So Title III retailers is 28 CFR Part 36.101 and so forth. Okay, there's like 4 or 5
Yeah, I'm pulling up
subpart
the
A, B,
contents,
C.
by the way, because I have a
Yeah,
table of contents on our website,
there you
which
go.
is
Yeah,
on
click on
our
that.
face mask dangers and law page. So let's see if
Good.
we got that right. 36.
Part 36.203.
36.203.
You guys want to go back about 4 minutes and listen to what the way I describe this because it's so important. You're being regarded as having a communicable disease. In other words, you're being regarded as having a disability, and you're being forced or asked to submit to mitigation measures, which you're not required to accept. And they're required, if you choose not to accept them, they're required to prove you're a direct threat. Otherwise, they have to give you equal access.
You
That's
said
the language.
you said 36.203C, and
Yeah, it's
it says there
28.
accommodations and services.
Yeah,
One, nothing in this part shall be construed to require an individual with a disability to accept an accommodation and service opportunity
thank
or
you.
benefit available under
There
the
it is.
part.
And
Yeah.
there's one under Part 35. Okay, Part 35 is for public buildings, courts, libraries, whatever public schools probably. So I forget what section it is, but there's a corresponding. They're numbered differently in parts 35 and 36. 28 CFR Part 35 is Title II ADA, and 28 CFR Part 36 is Title III ADA, and then
So,
29 CFR Part 1630 is Title I ADA.
and again, for clarity, what we're saying is you're saying you're claiming you believe that I have a disability. So you're saying I have a disability. So I'm covered under the
That's
Americans with
right.
Disabilities Act. And you're saying, here's your mitigating
Right.
thing. You want me to wear
Measure.
a face mask, but I have the right under law to refuse that mitigation.
Absolutely. That's the language you use instead of I have
Right,
constitutional right, it's due process. You
right,
replace it with the ADA stuff because
right.
that is going to lead to a cause of action that you can win on. And I'll tell you what we're starting to do
And
on
again,
these cases.
let's catch that, John, because explain how that's going to lead to a cause of action.
Okay, because okay, if you go in and try to resolve this, and you go to a mediator or a judge, and you say, I told him I had a disability, and I asked for reasonable accommodations, or I told him that I had a disability, and I said I had a difficult time breathing. Okay, now that's how you set up the foundation of your complaint. If you go in there and say I have a religious exemption, and then later you talk about disability, you're done. Forget it. You can't
Right.
do that.
What
And
about
that's a really hard
piggybacking the
case.
two? What about putting the two together?
Can't do it. You're not going to be able to. It's not going to be it's not going to be a case. You
So
need to
let's just
identify that.
let's sidetrack just for a second then and address the religious again, because most people, and I'd like to think, you know what, and I don't know if I forwarded it to you or not. I'm going to forward it to you as soon as we're off here, where we had a firefighter contact us, a couple months
Yeah,
ago because he saw the
right.
work we're doing, and he asked us. So he wrote up a letter saying, my breathing is my, God breathed into
Yeah,
Adam's nostrils the breath of life. This is my direct connection with the Creator. You cannot interfere with that, right?
you can win on that case. I don't know how to do it. It's very expensive. There are some attorneys. It'll probably cost you $25,000, and you'll probably win on that. There's really good case law on it. I'm just talking to people like you and me that just want to get on with their lives, and we're not
Right,
going to spend 100 grand at this stuff, and we
right.
have a pretty good chance. And I'm finding there's some cases right now that are being resolved without going to court. And just because we're using the ADA correctly, if you do it correctly from the beginning, they know you can't be pushed around because they know that either you're getting help, they know you're getting help, but they can't do anything about it. So
Right.
someone's helping you write these documents, but they're written correctly, and they know that if it's useless to force the situation into a court because they're going to lose, and then they're going to lose on the public record. And this is
Right.
what's happening with Costco right now. We got Costco now. We cornered them.
Now you're
They're-
talking about Abs, Uncle
I-
Odd's case, by
I'm just saying, Costco, you guys are going to end up changing your policy. You know what I'm talking about. I'm not going to get too much into it, but
right,
this is not going to end well for them.
right.
Uh, but I'll just, real quick, we just had a, just not even, this is like one of the few times I do this. Somebody I'm working with did a handwritten motion to the court. Okay. It ended up in the judge recusing himself. It's a criminal proceeding because he's being charged with trespass for not wearing a mask in a restaurant. Okay. He did a handwritten note to the judge, and the judge had to recuse himself.
Mm,
And
yeah,
it was about the ADA. This is how powerful this stuff is.
yeah, yeah. It
We're
is.
not done with that judge. We've got a whole show to produce on that one.
Great.
But yeah, it's just
Yeah,
now
let's
getting
address
started.
this, John, while we're on that. Because one of the things I'll often tell people as well is too many people, I think, are saying they get caught up in this medical exemption, right? That it has to be a
Yeah.
medical. No, it's
Yeah.
a
You don't want to say
health
that.
condition, a health condition
You want to
that
say
may be,
disability.
what's
You want to
that?
say disability. You want to say disability. Use that word, disability. And here's
Disability.
how I use it. I don't go in there and say I have a disability. It prevents me from breathing, because the disability involves impeding your ability to breathe, eat, walk, think, or do things that you would normally do, or even see. I've seen people with a mask and their glasses get fogged up. So the disability is quite involved, and it's not exhaustive in the statute. If you can come
Right.
up with a way it's affecting you, then it's a disability. Okay.
Right. And,
There are
and it
three.
even states in there that it's very broad, deliberately
Yeah.
broad
Yeah.
reaching. It has
There
to
are.
be because there's so many
Yeah.
possibilities.
There is. There are three prongs here. They're called prongs, three categories of disability. One is you're regarded as having the disability. The other one is you have an actual or apparent disability. Like you just experienced this, but you've never had it diagnosed. The third prong is you have it of record or diagnosed. It can be a combination of the latter two. It could be actual, which is where you have to explain a little bit. Like, for example, if I wear a mask, I feel lightheaded and have headaches. That is enough to establish a disability. And by the
Mhm.
way, when you go into this process and you talk about a disability, you do not have to prove your disability, and you don't have to discuss it. You
Exactly.
don't have to discuss it. It can be discussed with a mediator, but not with the other party. They try to intimidate you by saying, okay, tell us about your disability. That's what they do. And they want to re-diagnose your disability. They're not allowed to do that. What they have to do is prove that you're a threat.
Elaborate
They're
on
not,
that. Elaborate
yeah,
on that. Most people reference HIPAA, but elaborate on, in
okay.
Florida, we have
Yeah,
rights of privacy.
yeah.
Some
The
people will reference,
HIPAA doesn't pertain to this at all.
right.
HIPAA is a statutory, let's call it a statutory data retention policy for certain covered organizations like physicians assistants, and maybe some other quasi-medical type things like spas, and maybe some software applications that collect your data. Okay, those are covered and partially covered organizations that are subject to HIPAA disclosure requirements. When you disclose your information to a physician or anybody, any third party, even your friend, when you let them take your temperature, you're giving up medical or vital statistics, okay, medical data. The conditions under which you give that data are binding on both parties. So that's why HIPAA doesn't matter, because if as soon as you give up medical data or vital statistics, whatever conditions you did that under are binding. So there's no HIPAA violation. The fact that you disclosed it eliminates HIPAA.
Right. So the protections come from,
The
I mean,
protections come from the classification of a disability, and the fact that you don't have to prove your disability. You just have to say that I have a difficulty breathing or whatever, and then the other side has to prove that you're a direct threat.
right. So
The
that's
only
covered in the ADA as well, that you
Yeah,
do not have to disclose,
yes, yes, because it's okay. Go
which it
look at
should be.
okay, go look at 42 USC, and I'm going to
Yeah.
give you the statute here because you can look in the reg, but I'm going to give you the statute for the whole thing. 42 USC section 12203, and I forget which paragraph in there, but it's B, 12203B, and it talks about,
I'm sorry, repeat it again.
it's 42 USC 12203 section B, and it talks about coercion, intimidation, and threats. Retaliation is what it talks about, retaliation. So when someone says, oh, really, you have a disability? What kind of disability do you have? That is called retaliation.
Right.
Or if someone says, we're not going to sell you goods today because you won't wear a mask, that's retaliation for against you exercising a right because you have a disability or because you're regarded as having a disability. So there's the statute actually covers retaliation. If they
Yeah, I'm
threaten
seeing
you
it.
with arrest or threaten you with public humiliation or tell you have to talk about your disability,
John,
that's all retaliation.
John, I mean, that's a golden nugget you just dropped for everybody, because I'm constantly, referencing 42 USC just on the basis of, having the equal access. But
Right.
here it is, like you said,
You cannot
interference,
retaliate against
coercion,
me.
or
Yes.
intimidation.
Yeah. It's anybody who tries to
It
make you
shall
talk about
be
your
unlawful to coerce, intimidate, threaten, or interfere with any individual in the
and that
exercise or enjoyment of, or on account of his or her having exercised or enjoyed, or on account of his or her having aided or encouraged any other individual in the exercise or enjoyment of any right granted or protected by this chapter.
now here you just said a phrase here, aided or encouraged, right? So if I go into a grocery store and the grocery store considers me to have a disability and says you have to wear a mask and I say I can't, it inhibits my ability to breathe, and they say, okay, that's great, have a nice day. Now they're aiding you in a mitigating measure that's suitable for your condition. That is the duty of the retailer. He's exercising a proper duty of care by aiding and encouraging people under the ADA. So that's when the Department of Health comes in and says, no, you have to deny everybody as if they're a direct threat. And he says, no, I'm aiding and encouraging people with a disability. And that guy said he couldn't wear a mask. And so I'm hands off now. You can't penalize me for that.
That's
You
right.
see how
That's
powerful
right.
this is? You can use it to protect the whole business against the Department of Health and whoever else.
That's right. And on that note, John, that's beautiful, buddy. Um, Let me just add this to the mix, because this is another thing that I've referenced. I want to make it clear for people, and you can elaborate on this, after I get it out of my head here. I'll use examples like when I originally wrote to the Department of Justice. I was, because last year a lot of people were trying to make sense of all this, because nobody knew about these laws even, right? Because nobody ever thought that they were going to be told they have to cover their vital airways. We're living in like some kind of a twilight
La La
zone here,
Land,
right?
right?
Right. So when people started looking into it, one of the big things that just occurred to me naturally is I'm like, wait a minute, you don't know if somebody, when they were a child, when they would cry, they had a crazy parent that got angry and wrapped a scarf around their
Oh
face
my
and put a
gosh.
bag over their head and set
Right.
them in a closet. You don't know if a young
Right.
girl or a young woman was gang raped and had a sack put over her head and was violated. You don't know if
Right.
somebody got in a car accident and it knocked them silly and anything on their head disturbs them. And we could go on and on and
Yep.
on and on with all the numerous examples of what could be the reason.
That's right. That's
And
what
that
that's
has
the
to be
whole idea
protected.
behind it.
That's the
It
whole
is
idea behind it.
protected, but you have to understand what that is. So just know that what we already had, property rights that are protected, now it's in a statute called Americans with Disabilities Act. And I'll leave you with one thing, and let me just suggest, Mike, we have all this material available through a new website we're just launching. I'm not going to announce it, but I would like to, when it's ready, announce it through your channel. If we could do that.
Absolutely. We're going to
Okay.
link it on our
All right, let's do
website.
that. So guys, we're gonna have some good stuff. If you guys want to use it, we have some really cool services. There's a lot of good people I've been working with the last few months. They're trained. We're getting this ready. It's going to be awesome. We're going to do a lot of good things. I'd love to tell you
And
about more.
you're going to
Casey.
be a link on the top of our homepage,
Okay.
John. It'll be a link
All
on the
right.
top of our homepage
All right. Awesome.
at thebigvirushoax.com.
Okay. So anyways, I slipped my mind. I was going to tell you one thing, but no, I think we covered some pretty good
Well, were you
things.
about to elaborate on, because I was saying there's so many possibilities on what a person's disability could be.
Yeah. I mean, gosh, just know that you have a right to keep your disability to yourself, and
Right.
you don't have to talk about it. But when someone is forcing a mitigation measure on you, I just have to get this language in my head. They have to prove that you are a direct threat, and they have to have conducted an individual assessment, and that's where it starts.
And that's due process.
That is due process, exactly. So that's just a different way to say it. And so here's what. Okay, so one thing I want to leave you guys with is I like to use humor when I talk about this stuff. So if I'm talking to a retailer, I'll just make up a story, and I'll do this in court too. I'll make an analogy as a legal argument, okay, which is what a good attorney would do is to try to convince someone or persuade them. So what I tell people is, I have this role I play, and they'll say, "Oh, sir, here's a mask. If you would please wear a mask when you come in our store." And I say, "Oh my God, I did that last week, and I collapsed. I was unconscious. I don't even know for how long, but when I woke up, they had an ambulance and everything, and now I got to pay. It's like $2,800 to pay." And that's, I mean, I could just make up. I could keep on talking for a half hour because I'll just keep making stuff up, and they'll just eat it up, and they just interrupt me and say, "Okay, sir, that's fine. Just keep on going. You're good."
Yeah. And
I've
that
never
proves
had a
the point.
problem with that.
Yeah.
Yeah, but see, here's what I did though. I said I had a disability that resulted in this type of situation. I didn't use technical language of the ADA. I just made
Right.
up a story.
Right.
And if you guys are comfortable with that, I mean, it might be more effective to talk to, like, I mean, the people I usually talk to are like teenagers, right? There's young people. They're just doing what they're told, and then I give them that story, and it totally dazes them. They don't know what to
Yeah.
do, you know.
Yeah.
So
Well,
if that helps you guys,
yeah, no, it helps a lot, brother. And I like the fact that you stress the word disability. It's
yeah,
your disability. Yeah.
they're saying you have a disability. Okay, fine. Let's talk about that. So that's all you
Right.
got to talk about.
All right. We could go on, but let's keep this spiffy. That was
Thanks,
great,
Mike.
John.
Good plan. Yeah,
I appreciate
upload
it.
this video, and I'll link to it. In fact, if you give me a copy, I'll put it on my channel, and then
Absolutely. I'll send
well,
it to you here shortly.
when we
God
do our
bless you, brother.
announcement. All right.
All right. Have a great
Thanks,
day,
Mike.
man.
You
All right.
too.
Bye.
Bye.